Hey guys, let's go over some of the remaining mysteries in the Manson versus Wood Gore case. Let's stop the crazy train first at the Ashley Smith line DMs. Manson's team submitted declarations purporting to show direct messages on Instagram between Ashley Smith line and somebody else, the basic nut of which was that she had been coerced or pressured or whatever into making these allegations against Manson and really wished it all would go away. She just wanted to live her life. That would all be pretty devastating to her case, of course, if it's true. And it would certainly be bad against Wood and Gore because it supports Manson's contention that they tried to pressure women into making allegations against him. But shortly after that, it appeared on the internet a set of direct messages purporting to say, no, I didn't write those things. That's the hackers did that. Crazy hacker stalkers. I've moved away. I wish they would just leave me alone. They all want me dead. And those made the rounds on the internet and then were brought in by Sean Hawley into the case, but not as evidence, but rather just to show, Judge, look at this crazy world we live in. Pictures of DMs don't mean anything. Kind of got to go with her on that one. I mean, who the hell really knows, right? And what's more particularly curious on this to me is if these women were a unit, a group of people conspiring against Manson, and she did not write these DMs, why didn't she give Wood's team a one-page declaration saying, look, this is my account. I've never written any of these things. I didn't claim that I was pressured. All of that is manufactured by somebody else. Why not blow it out of the water? I don't know the answer to that. Also, if these other DMs are supposed to be authentic, where she allegedly says, no, I didn't write any of that, why would you answer these purported fake DMs with another DM? Why not just put a post on Instagram saying, look, I know that there have been fake DMs sent around saying that I was pressured into making the allegations I've made. That's all false. That's part of the campaign against me. Why not put something out in public? I don't know the answer to that either. Now, in theory, she sat for a deposition on August 17th by Manson's attorneys for the Bianco case. And Manson's attorneys had referenced in their brief to the court in the Wood case that they could use that deposition to support their opposition to the motion to strike. And they could if they get it in time and all of that. I'm not even sure if it even happened. It probably did, but a deposition is not a public proceeding. And we'll talk a little bit about what that deposition is good for, because there may be some misconceptions around that. It's certainly sworn testimony. She's going to be sworn in, and for the purposes of the Bianco case, she's going to be given testimony. It's a discovery deposition. It's used for discovery purposes in the Bianco case. What else can it be used for? So in a federal court deposition like that, it's not a public document per se. It's not going to be on the court's docket for you to just go look at. And the court reporters aren't going to sell you a copy of it if you call them. So the way you would get it is either one of the parties files it in a court proceeding and then you can see it there, or one of the parties publishes it or leaks it. Because it's not inherently confidential unless there's a confidentiality order that the court has given. I don't think there was one in that case. So it's kind of, it's some kind of gray area there where it's not secret, but it's not easy to get to. If it had been a California state deposition, they actually have a procedure. If you know the court reporter, you can call and request to purchase a copy. Then a court reporter will notify the parties and they can attempt to object to that. But otherwise, you could get a copy of it at least, even as a member of the public. So Manson's attorneys will have this deposition, and Bianco's attorneys will have this deposition, and Smith Line's attorney will have that deposition. By the way, that's the same attorney representing those women. Wood and Gore will not necessarily have that deposition unless it's given to them by one of the parties to the case. And you ought to see right there could be an issue on how can you use this deposition in the Wood-Gore case. So Manson's attorneys in their brief say that for purposes of opposing the motion to strike, they could use this deposition, even though it is hearsay. Deposition is generally hearsay, because hearsay could be cured at trial later on. As long as you can connect that up to some degree, then it's appropriate for purposes of the motion to strike to consider what it has to say. So I think they're right on that. If they get the deposition and it provides favorable testimony, they should put it in front of the court in the Wood-Gore case for purposes of this motion and use it to support what they have to say. Now that is different than if the case goes on to trial thinking, well, yay, I have this deposition. It's freaking awesome for my case. Let me just ride on into court here, hit play on the TV, put my feet up on the desk, and watch my case build itself. It doesn't really work like that. California has, like a lot of states do, some strange laws that if you read just one part of it, you think it means this, and you read another part and it means that, and then you have to go to the court to say, what the hell is all this supposed to mean? So a deposition is hearsay. Now, if Ashley Smithline were called to testify in the Wood-Gore case, and she said something there that is inconsistent with this deposition, they absolutely would be able to use it to impeach her, to say, wait a minute, didn't you say on this date something different? And your recollection would have been better because that was closer to the event, all the things you would say during an impeachment situation. But can Manson's attorneys just hit play on the TV and sit back and let her talk about whatever it is they ask her about in this discovery deposition in the Bianco case? And the answer to that is, generally speaking, going to be no. Because you have to meet a series of tests before you can enter the deposition as substantive evidence in California. Again, there are some statutes that I think are more permissive reading, but the Supreme Court of California recently decided we're not going to go into those because we're dealing with this more particular hearsay exception, and that's what they recently addressed. So let's talk about that. That was a case, a mass tort case, where somebody was suing Ford over something to do with a truck, and lawsuits continued, different lawsuits over a period of years, and they kept taking depositions of people from Ford, and they would use them in the next cases. And Ford ended up objecting to that, and it went up to the California Supreme Court and was decided this year that as a general rule, you cannot admit civil depositions as substantive testimony in an action unless certain tests are met. So let's talk about what those tests are. The first is the person has to be unavailable. So they got to be far away or not subject to the power of the court, or they're dead or something like that. Then the party against whom the former testimony is offered was a party to the action, and that was true in the Ford case, and had the right and opportunity to cross-examine the declarant with an interest and motive similar to that which he has at the hearing. And that became a problem for the plaintiff in the Ford case because the Supreme Court of California said that your motive and interest in cross-examining your own witnesses in a discovery deposition are far different than they would be to ask questions of this person at a trial. And that's certainly true. At a deposition, if it's just a discovery deposition, you don't want to ask your own client a bunch of questions because that gives the other counsel time to think about more questions to ask. It may expose some weaknesses to your case. You're not there to prove your case. You're there for discovery purposes. Just answer the question only is what you teach people to do in a deposition like that. So the Supreme Court said that as a general rule, when you're in a deposition that's a discovery type deposition, you're not going to have an interest in engaging in cross-examination. So you're not meeting this element of the test, even if you're a party, even if it's a trial kind of about the same thing. And that is the practice for depositions. So the court sent out a series of tests, etc., about how the deposition has to be like a trial kind of deposition, and they have to understand it, and things that could cause it to tilt the other way, where you would have this motive for cross-examining like you would if the person had gone and given live testimony at court. So how does this relate to Smithline's deposition in the Bianco case for the Wood-Gore case? First of all, she's not even unavailable. If they can depose her for this other case there, they could call her as a witness for this case. Of course, she could become unavailable, but for right now, she's not even meeting the first test. But the second test is they have to be a party to the case. And Wood-Gore had no opportunity to cross-examine Smithline in this other deposition. They were not a party to that action for that deposition. So it doesn't meet any of these criteria, and I think, therefore, they would be able to have it excluded under the Supreme Court's reasoning as hearsay, and no exception to it unless it's used for impeachment. Some things could change that, but generally speaking, think about the fairness of this. If she's questioned by Manson's attorneys and then disappears somewhere, and Wood-Gore never had a chance to ask their questions of the case, how fair would it be to have this just played out in front of the trial? So the right way to do it would be to call her for testimony live in court, or if Manson's claims do survive the motion to strike, and that can partly be bolstered by this deposition because, again, that's not courtroom testimony. It can be hearsay for the motion. then he should either plan to call her as a witness in this case or take a deposition under the criteria that would meet the court's test, with Wood and Gore being able to cross-examine so that if she becomes unavailable or is unavailable or whatever, you could potentially use it in trial. So another deposition, in other words, or call her as a witness. That's what you're supposed to do. So that puts some real limits on the evidentiary value of the deposition for the Wood-Gore case. It doesn't put any limits on it for narrative value, depending on what she says in it. Assuming it occurred, we don't know. Certainly, one of the things that was examined there were these DMs and what's really the answer there, because I think that matters a lot. If those DMs turn out to be false, it's a big black eye for Manson's team to have staked those out and put them in front of the court. If they turn out to be true, it's terrible for her case, and it hurts Wood and Gore as well. So I think it's a swing point of evidence in the case, and that's why people are interested in it and what else she has to say. But we won't know, at least for a while, and then only if somebody decides to release the thing or file it. This notion of the limitation of the use of a deposition or prior testimony, it's similar to the federal rule of civil procedure as well. Again, there are other California statutes that seem to be more permissive on the use of depositions, but this is the one that made it up in front of the California Supreme Court, and there they ruled against using these civil depositions in cases involving the same defendant, kind of even on the same issue involved in the prior trial. So that's fairly restrictive, and they basically said we have a general rule against using civil depositions as testimony in other cases, later cases, unless the person who wants to use it gets over the hurdles that we've set in front of them. So another kind of mystery to me still in this case is, who wrote the FBI letter? It's not a mystery to a lot of people who've already decided they know, and I completely respect that, because so far as the case appears, it's pretty much two people, Wood or Gore. And Wood has gone on the record with a declaration saying, I didn't create this letter. It does appear from a text message that she was involved in generating some early language that might have later become this letter, but she says, I didn't make this letter. And the logical conclusion from that is, well, then Gore did it. But we don't know that, right? We don't know it yet. It's just likely. I don't understand it. I don't understand why, if Wood had gone to the trouble to type up text to this letter, why she would need anybody to paste it onto a word processor to generate a one-page letter that has nothing on it other than this text and some handwritten notes about other people to contact and a fake signature. Like, why do you need a team of people to do that? Does that make any sense? I don't understand this letter. I don't understand even the theory that Gore made it, because I don't understand why she needed to make it. Why couldn't Wood just say, yeah, okay, I've finished changing it. Let me print this thing out. Now she says she didn't. And I think her attorneys would not have filed this declaration if they didn't have an understanding of the story behind this letter from start to finish. I think they do. And what they've revealed in the declaration are the pieces of it that they want the court to know right now to just try and support their motion to strike. But they have some kind of theory with this letter, at least Wood's attorneys do, that they hope to keep her out of hot water for, potentially having put forth a false letter intentionally. So they're saying that didn't happen. She didn't make this letter. She thought it was real when she got it. So they've got a narrative ready to go. They haven't put all of it on the table yet. And the fact that they didn't say where she got the letter from suggests to me that it came from somebody that she doesn't want to admit to right now. And who would that be? Either Gore or somebody else she wants to protect. So I would like to see that detail closed down, even though I agree that likely Gore helped her make it, but I don't know that. And you want to know these things if you're going to use them as like a crux in your case for the credibility of the parties. So we'll see. Another mystery to me are the terrible videos. I showed some clips in the last video I made of these Manson web videos where it depicts a woman being assaulted and bleeding and no clothes on. It's a terrible scene. I saw some comments about it. This is his humor. I don't even think Manson would say that's funny. I could see them saying this was part of some kind of art project, because I don't know what the hell is going on in those videos other than, to me, it looks quite terrible. But when I did look at it, one thing that was interesting was at one point the camera swings around and there appears at least to be someone standing in the background, and the camera turns around to the person closest to the woman who's being allegedly assaulted or depicted as assaulted, and it appears to be another woman. So I don't know what's going on with these videos. And a straightforward thought of what they depict, which is if you just watch them, you might reach the conclusion, hey, Manson's punching this woman. But that's not really what's going on with this video. If you look at it closely, because the camera switches back and forth, and there's Manson here, and then there's the woman there, you don't see him doing anything to her. So if he were the person doing it, or if it were real rather than staged or consented to or an art project or whatever, if it were real, and here's a picture of this woman with just blood pouring down her face, why in the world wouldn't you take a screenshot of that if you were Wood's attorneys and you're filing declarations anyway and put it in there somewhere? Because doesn't it taint the picture? I mean, I realize if you're a Manson fan, you say no because it's art, and what about Stephen King, and what about these movies? I got all that. Still, you have to agree that it looks bad. And that if you're a lawyer arguing for Wood, you want things that look bad for Manson, right? I mean, that's what you say that she does, that she makes up bad things against Manson. Why not use an image that's worth 1,000 words, right? Why not put this image of this woman bleeding into one of your declarations about him and say that was me? And I couldn't consent. But who would even consent to something like this? This proves I was drugged up at the time, or I participated in it, or whatever. I find it odd that here's a piece of evidence available in the public that in theory could support what she has to say, but it's not used in anything that she's put forward so far. Why not? So while it does look horrible to me, I gotta think there's some explanation maybe for this video that makes it not as bad as what it looks like, or else why wouldn't Wood use it? Still a little bit of a mystery to me, and maybe that one just goes away, or maybe it comes back later to be explained or put to bed or something like that. But I don't think it's a smoking gun against him per se, because I think if it were, it would just be already in the declarations. And how about, as another mystery, these fake email accounts that Manson says that he's found out about, that he says that Gore set up impersonating him, bhwarner1969@gmail.com, engaging in some kind of illicit pornography. And then also other accounts messaging back and forth to make it look like he's consulting with an attorney and they're saying things back and forth to each other. Manson said he gained access to these things in November 2021. I think that's about the time things blew up between the Gore sisters, and Brighton Gore ended up with an iPad, and I also believe some kind of Apple computer that had belonged to Ashley Gore, and it looks like communicated with Manson's team. Obviously, they got access to some of these things from Brighton Gore. She's given a declaration in their favor. So that may be when they found out about these emails and saw the things that they saw. Unfortunately, they didn't post any of that stuff up to the complaint like they did, the draft of the FBI letter. Not sure why not. It would have been pretty compelling to show another fake document created by one of the defendants, maybe even more directly linked to a defendant, to show this pattern of creating deceptive documents. Because that's pretty compelling. If somebody just continuously fabricating documents, how can you believe anything they're ever going to have to say? And if you can prove it, that's really good if you're Manson's team. And of course, they have a strong lead situation with this FBI letter that's has turned into kryptonite. Nobody wants to touch it. It's a hot potato on the defense side. They all want to disavow it. This same kind of thinking could occur regarding these email accounts, right? So I think Manson's saying he's got some smoking guns there, but he hasn't shown those yet in any detail. So I think that's also another mystery in the case, because this could really bolster up what Manson has to say. And he's gone out on a limb to some degree saying, I have this evidence. So when he shows it, it's either going to make his case a lot stronger or it could fizzle. I tend to think that he probably does have some of this stuff. I don't think that was imagined by his team to create this fake email name. I think they found this stuff, and I don't know why they didn't demonstrate more of it. Maybe they wanted to hold some cards in, maybe because of some of the content of it they want to use in some strategic way against the defendants. But when we see more of that, I think it's going to make the case stronger for Manson if it's what he says it is. So we'll just have to see. Another mystery is this Phoenix Act dissolution. And Evan Rachel Wood was going around talking about the Phoenix Act and her efforts to increase the statute of limitations for sexual assault, for criminal actions and civil actions. Some people are horrified by that. I don't get that. In North Carolina, for example, if you engage in a felony sexual assault, there is no statute of limitations. It could be 40 years, okay? There's no statute of limitations for felonies in this state. So the statute of limitations is, again, completely just a construct of the legislature to set limits that are arbitrary and achieve some kind of balance. So it is legitimate to want to change those. And her reasoning behind some of that is good. Maybe the length of time is too long. That's all debatable. But she set up this charitable organization to spearhead this effort. And then the funding looked very dire, right? And not a lot of money flowing through the organization. And then it gets shut down. It gets dissolved. And she doesn't mention that in public. It's not mentioned on their website. That seems shady to me. Why are you not telling people this? It continues to act the way that it did act. It had people associated with it, or at least they said they were. They were all in Florida, even though this thing was located in California. And that's not necessarily bad. But then you tie in Manson's attorney saying that when she spoke to Agent Langer, her only connection with any of these people were a couple of the people that she talked to, maybe that were these two people associated with the Phoenix Act. We don't have any further insight into that, except that that's not just some complete conspiracy by Manson, because Wood herself filed the paperwork to dissolve the organization. Why? Does this indicate a split in the defense between Wood and Gore, that something's going on between them? They have taken some different tacks in terms of their defenses. Don't know the answer to that, but I don't think it's just completely random that this organization slides down on the amount of money that's coming into it and then just goes out of business. That seems very bizarre. Why would you fold it up? Why wouldn't you? It doesn't cost hardly anything to keep an LLC open, or whatever, however it was formed. Why would you not keep the form there, keep the organization going? You already had the structure in place. Instead, it gets dissolved. I find that very strange. There's certainly some ideas in my mind of what might have happened, but I don't have any evidence for that. So I'm not going to throw that speculation on the table. But I know some people who aren't fans of hers probably can imagine what those things could be. I can't really think of a good reason to do it. And so to me, that's a point against whatever narrative that is constructed in favor of the Phoenix Act. The fact that it gets quietly shut down while nobody acknowledges that fact, I don't understand that. And I imagine if the cases go forward and continue forever, this is going to be subject to a larger deposition in this case. It wouldn't be, I don't think, for the limited purposes of the motion to strike. And finally, just a few comments on this investigation into Manson, and whether it was the FBI, whether it was the Sheriff's Department, or whether it was the DA's office, or whatever. There seems to be a notion to some people that it's super important to say he was under investigation, as if that proves something against him. Of course, it does not prove something against him, other than that people were motivated to make accusations sufficient enough to get law enforcement to check them out. That could be legitimate. It could be not legitimate. Now, there are other people who say, well, he was investigated, and the investigation was closed down based on reports from TMZ that they had issues with an accuser. Who knows if that's true or not? It's in TMZ, but it's just a leak. But it is factual, apparently, that he's not been arrested or anything done to him about this. And it's been quite a long while. So his supporters will say, well, to the degree there was an investigation, law enforcement powers were invoked, witnesses were interviewed, they even did a search warrant on him, and ultimately they didn't arrest him even for jaywalking. So how much credence can you give to these accusations if they went through his house, they talked to all these people, and they got nothing to go forward with? And I appreciate the context of that. However, that doesn't prove he didn't do anything, because the DA has to look at it with statute of limitations in mind, and also whether it's likely to produce a result where they would get a conviction, convince a jury beyond a reasonable doubt. So hypothetically, in investigations, you could think, well, we got the right guy, we just can't prove it right now. So that could be the case too. I'm not saying it is. What I am saying is whether it's investigation or not doesn't prove he's innocent and doesn't prove he's guilty. It's just something that can be going on. And it did, however, take me down a rabbit hole when Sean Hawley filed her declaration showing FBI emails between her and an FBI agent, the people who didn't want to admit that Manson may have ever been subject to any scrutiny by the FBI, despite the fact that it's not hard to make that happen. You can just call them and make allegations, right? Tried to say that the agent was fake, that the emails were fake, with a lot of ridiculous reasoning. Some of which was, look at this picture of the email. You see how blurred it is where her name is and stuff. So that shows that it was photoshopped. That picture itself is not, that was shown on Twitter and also Instagram, is not what the email looks like at the courthouse, because you yourself, like I did, can go on to the court's website and download her actual declaration. And the image you'll see looks like this, where it's all crisp and clear. So how did there become an image that people started to talk about that is blurry? Don't you wonder that before you start trusting people about whether things are made up or not, that the image begins to change, a digital image? Why'd that happen? I don't know why it happened, but that was enough to shut me off of that discussion. They also said, oh, look, it says external email. That can't be the FBI, bro. Well, here's an FBI email that was released by FOIA request that actually shows a similar kind of context to the email where it says external email. And that was produced in FBI, completely different context in this case, but it shows how their system works. And so if you're finally down the rabbit hole of, well, it can't be an FBI agent because they don't use initials, man. They just use full legal names. And you're completely unhinged. That's absolutely not true. I mean, I have emails on my own account from federal agents doing things similar to that. They write like other people do because they're actual human beings. And so if you're discrediting what Sean Hawley submitted to the court based on your supreme expert knowledge of how the FBI agents all around the country all write every email that they ever write, I don't think so. One person even said that they don't think that Sean Hawley even knew about these emails. Sean Hawley's the person who submitted them to the court with her name on it. So she did know about them. She's the person who put them in at the courthouse, right? So all that's to say is be careful who you believe and what you trust, because right now there's a lot of things floating around on some of these mysteries, and people have different motives for doing it. People also have different skill levels, and they have different levels of judgment, and they sometimes are highly motivated to tell you they absolutely know things that if you know anything about it, you know what they're saying is flat ridiculous. And it's unfortunate to see people brought into that, but you can't change the internet. You can't fix the internet. You can't fix everything. So it's just going to happen. So believe what the lies you like is something that I think, but keep a skeptical mindset when people are trying to convince you of something, whether it's me or whether it's anyone else. Look at the stuff yourself if you need to. Go behind the person and check it. I mean, certainly earlier in this case, when I received some information from some people who were interested in one side of the case, before I said anything about what it ultimately demonstrated, I went to the court website myself and validated the stuff before I put it out onto a video. That's just to satisfy myself. You don't have to believe me, but what I'm suggesting is that process is something that's useful for you to engage in. So when somebody shows you a picture of something and says, look at this, it proves it's all fake. How do you know the picture they're showing you isn't the fake thing? Like this blurred up image of this FBI email. So we got some mysteries out there, and we'll see if we get any clarity on those as things move forward. I haven't seen a rescheduling of the discovery hearing for the court in this case, so I'm suspecting they'll use the block of time that they had for the anti-SLAPP motions to do that hearing. That could be wrong. It could pop up before then, but it's getting close. So they have a little block of time of the court. It strikes me that's what they would use for this. But if it changes, I'm sure somebody will post that up and we'll see what happens. Thanks, bye.